Well, hello, good afternoon. Welcome to this webinar presented by 42BR barristers, hoarding litigation, what to do and what not to do. Okay, so let's do some introductions. My name is Iris Ferber at KC. I am a barrister specialising in housing and employment litigation, and in particular, I specialise in cases involving mental health.
My name is Krishma Patel. I'm a barrister specialising in social housing and general landlord and tenant.
And Krishma, hoarding. It's one of the most difficult types of case that we as housing barristers deal with.
Yeah.
There's never only one solution to it, but how to even start to approach resolving a hoarding problem with a tenant. Let's talk about that. Let's start with the story, though. I think it's going to help us to put some structure on the conversation if we have some facts.
Yeah.
And these facts come from a real case reported in the Court of Protection last year. We don't know the real name of this tenant because, as always happens with Court of Protection cases, the facts are there, but the individuals are all anonymised.
Yeah.
So we know the case as local authority versus X. That's the name of the case. And we have decided that we're going to call the tenant in this case Anna. So
Anna.
Tell me about Anna.
Okay, so Anna is the sole occupier of a flat. She's got a long-term diagnosis of OCD and hoarding disorder. Her symptoms are described as consistently severe. She also does have a history of detention under the Mental Health Act 1983, although nothing recently. She is currently effectively confined to her flat. She does receive some support in the form of limited home visits with mental health services, for example, but her hoarding is at a very severe level. So it's 9 out of 9 on the clutter image rating scale. And just pausing here.
Yes, yeah. What is that? Tell me about that.
For a moment. So it's a tool. It's a series of standard photographs. Each page includes, for example, images of a different room. So that includes a kitchen, bathroom, bedroom, a living room, etc. And
so if I go to a particular page, I'll see pictures of a kitchen.
Correct.
Right.
Correct. And so each page will show a series of images of that room, like you just said, the kitchen.
Okay.
In various stages of clutter. So from image one to image 9. Right. Image 1 being
normal.
Yes, acceptable, and image 9 being very severe extreme hoarding.
Okay.
And so what this tool does is that it helps to standardize definitions of the level of clutter, because it allows the observer to effectively select an image on the scale that best corresponds with the state of each room in the tenant's home. So if we go back now to Anna's story, her flat scored 9 out of 9 on the clutter image rating scale, and that's the worst possible level of clutter. So there's a substantial fire risk in her property. Threats of self-harm have been made when access has been attempted. Threats against council officers when access has actually been given. Mostly access has been refused in Anna's case.
By Anna.
By Anna. Okay. And many appointments have also been cancelled by Anna at the last minute.
Okay, well that sounds very serious. Let's start then, before we tackle anything else, with a general chat about what we think a landlord could do, should think about doing in general terms in this type of situation. And then we can go back and talk about the law, what not to do.
Okay. So we know from the fact that I've already mentioned that the landlord has tried to visit Anna, to talk to her. Right.
Now that's very important, isn't it? And in all the technicalities we're going to talk about, that must not be forgotten.
Yeah.
That the first thing that a landlord must try is to engage with the tenant, talk to them face to face.
Absolutely. And so what sort of things might the landlord tenancy officer, for example, want to talk to Anna about if they are able to go and visit her?
Well, the most obvious thing, but perhaps something that occasionally gets forgotten a bit in all of the technicalities, is asking Anna. Asking the tenant who is hoarding what they want to happen. Are they willing? Is Anna willing to start on some clearing? And that usually takes the form of making a clearance plan. Is she willing to do that? perhaps with help.
Mhm.
And on that subject, is there somebody, maybe a friend, family member, neighbour, that she trusts, that she would be willing to get involved to help her with starting to do that? Is she willing to engage with tenancy support services, maybe just to start to do that, with medical services, with counselling services? Is she willing to agree to be referred to adult social care in the relevant local authority? So those are the questions to explore with Anna at that meeting.
And in addition to those questions, what about other things that a landlord tenancy officer could do whilst, for example, they're in the property and they're visiting her?
Okay, well, there are a couple of assessments that they should try to carry out while they are there. Firstly, their own clutter image rating assessment of the level of clutter.
Yeah.
Because it might well be that that officer is the first person who's been able to visit that flat for a long time, and things might have got a lot worse since the last visit, improved. An assessment. And that means, on a practical level, either print out a copy, a colour copy of the clutter image rating tool, and take it along and fill it in, or maybe take an iPad like I've got here along with the tool on it and do it that way. Maybe not necessarily something that the tenant will appreciate, an officer walking around and assessing the clutter. So it may be that the officer is looking around, taking a mental note of how things look, and then afterwards, when they've finished the appointment, sitting down with the clutter image rating tool and assessing the clutter at that point. So an assessment of the level of clutter, very important if it can be done on that visit. And then a non-medical assessment, a sort of common sense assessment of Anna's level of insight into her property. How much is she able or willing to understand that there actually is a problem that needs.
And so just before actually we start talking about Anna's level of insight, how do we make a meaningful assessment of Anna's mental state? So can we make a sort of tentative list of the sorts of legal action that a landlord could take in principle?
Yes. So, okay. So let's park the mental state bit. Let's think about potential legal steps then. Well, let me ask you, what in a situation where a tenant isn't doing something that the landlord wants them to do, like clearing a property or anything else, what's the first thing that you might think of doing as a landlord?
Possibly antisocial behaviour injunction.
Right, I think so. I think that's the sort of obvious thing a landlord would think about. So that's one legal step that could be taken. You might well get to that point. There is another type of legal step which I think a lot of landlords perhaps aren't familiar with, which is a notice under Section 287 of the Public Health Act 1936. If you're a local authority, that gives actually quite wide powers to forcibly gain entry and remove clutter from a property if it is a threat to public health. So that's a slightly different sort of order, but for some landlords that might be an option. And again, like with an injunction, it effectively forces the tenant into a particular road. And there are other more drastic possibilities too, beyond injunctions and public health notices. Potentially getting Anna sectioned sounds brutal, and it may not resolve the problem, but it depends on the sort of mental health problem that Anna has. So possibly it may be appropriate for Anna to be sectioned. Possibly it may be a case of going to the Court of Protection, like the local authority did in the case, the actual case of Anna that we're talking about. Go to the Court of Protection for an order that forcibly removes Anna from the property and then allows the landlord to declutter on her behalf. And ultimately, final thing, if all else fails, landlord can make a claim for possession.
So that's quite a range of actions, actually. Can any of them be attempted at any time, or are there very specific requirements for one or all of them?
Well, it's definitely not a sort of shopping list and you just pick anyone that you like. There are lots of limits, different types of limits on each of those actions, and some of them are things that you have to try before you get to other ones. So let's step back then. So we want to talk about that. We want to talk about what to do at what point. And before we can do that, let us step back
Yeah.
Start at the beginning. We have talked about practical things a little bit.
Mhm.
We've talked about a sort of shopping list of legal steps a
Mhm.
little bit. Let's step back. What might be, Krishna,
Mhm.
the first basic question, if you're a landlord, that you're going to ask yourself about Anna?
Whether or not she's got capacity
Yes,
is
exactly.
yeah.
I think that is the key question. And stepping even back one step from that, what do we mean by capacity? And I've also heard the phrase issue-specific capacity. What does that all mean?
Okay, so capacity definition comes from the Mental Capacity Act 2005, contained in section 2(1). And it reads like this. It says, a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. So essentially,
That's quite a mouthful.
Okay,
break it down for me.
Let me break it down. So essentially, it's a two-stage test.
Okay.
Stage one, we'll call that functional test. Is the person unable to make a particular decision?
Okay.
And then we move on to stage two, which is the diagnostic test.
The medical bit.
The medical bit.
Right.
And the question you want to ask there is the inability to make a decision caused by an impairment of or disturbance in the functioning of a person's mind or brain?
So what does that mean?
So,
give me examples.
Okay. So this could be due to long-term conditions, for example, mental illness, dementia, learning disability, etc. Or
so that's an impairment.
Exactly.
Probably.
Exactly.
Okay.
Or on the flip side, there could be more temporary states of confusion, unconsciousness, the effects of drugs or alcohol.
So that's more like a disturbance in
Yeah.
the functioning. Okay, what about issue-specific capacity? What does that mean?
So issue-specific capacity is just a way of explaining that the definition in section 2 of the Mental Capacity Act, the inability to make a decision for himself, relates to specific decisions. And it's not sort of a general, it's not about some sort of general decision-making ability, it's about something specific.
Okay, so you gave me the definition. A person lacks capacity in relation to a matter. And that means a particular thing.
Yes.
Right. So I think you mean, let me think of an example. Anna, our tenant,
Yeah.
she might have capacity to decide when she goes to the supermarket what food to buy for dinner.
Yeah.
That's a decision, and she can make that decision.
Yep.
She has capacity to make that decision. But at the same time, she might not have the capacity to make a decision about whether or not to clear the rubbish from her flat.
Exactly.
Okay, so let's just think about that in the context of injunctions, because I think many landlords and many solicitors acting for landlords will go to an injunction as the first thing they think of when they think of steps that could be taken to deal with hoarding. So thinking about capacity and thinking about injunctions, there are two particular things, aren't they, that relate to injunctions that are issues of capacity. The first, can the person who may be made subject to this attempted injunction, can Anna understand what an injunction means? In other words, does she have the ability to understand that it would be an order from the court telling her that she must do something or telling her that she must not do something, and the effect of not complying with that order would be potentially that she may go to prison? Does she understand that concept? Number one. And if she can't understand it, she may not have capacity to comply with it because she doesn't understand what it is. But quite separately from that, even if she does understand all of those things, does she have the ability to make a meaningful decision about her own behaviour? Is she able to control her behaviour sufficiently so as to comply with the injunction? And that two-step capacity test for injunctions, the ability to understand the injunction and the ability to comply, the ability to behave in a way demanded by the injunction. That comes from a very old case now, much older than the Mental Capacity Act. Case of Wookey and Wookey from 1991. You can probably tell from the name of the case it was a family law case because it was a husband and wife, Wookey. And Mr. Wookey had severe mental illness and a non-molestation order had been made against him, but he was completely incapable of complying with it because he was his mental illness meant that he couldn't control his behaviour. And in that case, the court decided that it was impossible for the court to make an order against somebody that could not be complied with.
Yeah. Okay. And so if Anna, in our case, doesn't have the capacity, so if she either doesn't have the capacity to understand what an injunction to clear her flat is, or if she can't clear her flat, even if she understands what the injunction actually says, then an injunction must not be made. It would be unenforceable.
Right.
So, yeah.
Yeah.
And so that would mean trying to get one would be a waste of time and money. But on the other hand, if Anna does have capacity to make decisions about her hoarding, then the Court of Protection won't have jurisdiction to make any orders about that. And so working out what Anna has capacity to do is crucial, and that's got to be sorted out first, surely.
Yeah, that's right. Either she doesn't have capacity to comply with an injunction, then injunction can't be made.
Yeah.
But if she does have capacity, particularly to deal with the hoarding, the Court of Protection simply doesn't have the jurisdiction then to do anything at all. I'm just looking at my screen. I know we said we'd take questions at the end, but I'm just looking at the screen.
Yeah.
Somebody has asked a question about options which are available if the property is privately owned. And that's a good point. The injunctions, generally speaking, are available to local authorities. Yeah. For a private landlord, the options are more limited.
Yeah.
And it may be that an injunction simply, well, it will be that an injunction simply isn't an option for a private landlord. In that case, you are looking at possession.
Yeah.
That is probably your only option. And we're going to come back, and I'll particularly mention private landlords when we come back to, once we've talked about these legal points, which, by the way, are relevant to all landlords. Capacity and other matters we're going to talk about, and then we'll come back to practical steps.
Yeah.
And the sort of practical steps that both private and social landlords need to think about. Okay, so we talked about the general definition of capacity, and we've talked about the two-stage test. What does unable to make a decision for herself, that bit of the definition, what does that actually mean?
And so actually that's defined even further in section 3 of the 2005 Act.
Okay.
And what it says is that a person is unable to make a decision for himself or herself if he or she is unable to understand the information relevant to the decision, or retain that information, or use or weigh that information as part of the process of making the decision, or to communicate his decision, and that's whether through talking, using sign language, or any other means.
Right. So let me get this right. There are 4 elements: understanding information, retaining information, using or weighing information, and then communicating. So you could have a situation where somebody's in, let's say, in a coma or in sort of vegetative state, can understand everything but cannot communicate. That person will lack capacity, even if they've got the understanding, the retention, the ability to weigh information. If they can't communicate it, then they lack capacity as defined in section 3 of the 2005 Act. And equally, if they understand the information and can communicate and can retain it, but they aren't able to weigh up, which is perhaps going to be the most vital situation for a hoarder. They understand the problem. They understand, they can retain the fact it's a problem. They can communicate, but they're incapable of weighing up the importance of, say, the fire risk against the idea of starting to the process of decluttering.
Exactly that.
So any element of those 4 types of issue, understanding information, retaining, understanding, weighing information, communication, any one of those things being missing gives rise to a lack of capacity.
That's right. That's right.
Okay. And the basic rule, and this goes right back to section 1 of the Mental Capacity Act. The basic rule is that there is a presumption, isn't there? A legal presumption that a person does have capacity to make any particular decision. That's the baseline, right? But, focusing again on hoarding, a tenant who is hoarding, almost by definition, is unlikely to have capacity in relation to decisions relating to decluttering. Because the reality is, if they had the capacity to make those decisions, they would be doing the decluttering. They'd be managing the contents of their home in a way that was more safe for them, safe for their neighbours. So probably, in a hoarding case, it's quite easy to rebut the presumption. But let's talk about this. Let's say it's not obvious whether there is capacity or isn't there. For example, because somebody appears to understand exactly what they're supposed to do, but just refuses to do it. And there isn't an obvious reason why that is. If it isn't obvious, whether the person is lacking capacity or just being difficult because they hate the landlord and they just want to cause trouble, say. If that's not obvious, what might a landlord need to do, and that's private or social landlord, what might a landlord need to do to establish whether or not the tenant has capacity, whether the presumption of capacity has been rebutted or hasn't been?
To get a medical report, and that's incredibly important. Maybe in our example, Anna will comply with an independent medical expert. It's more likely in practice that you're going to obtain a report from her GP, maybe, or even a specialist that's treating her already, if indeed there is one. An alternative to all of that is the local authority's mental health team.
And in fact, you could potentially seek reports for more than one, especially if they are already treated, if these are individuals who are already engaged with Anna. Right. So all of these things are helpful. Actually, an independent medical expert in litigation is often the most difficult thing to arrange, because people like Anna are often extremely wary of litigation, of the landlord, of anything that is an attempt to assess them. So it's generally much easier to get assessments from people who don't need to conduct a new assessment, but can actually give you the information based on what they already know about the individual. Okay, and when should the landlord start that process of obtaining medical evidence?
That should be immediate. It should be the first question to ask, really. Does the tenant lack capacity to manage her tenancy? Does the tenant lack capacity to comply with an injunction? Is it obvious, or are we going to need medical evidence here? Is the first thing, the first question that should be asked.
Okay, got that. So very first thing. We're going to move on to something else in a minute, but we've had a few questions that are specifically about capacity. So I think let's just run through those, see if we can answer them, and then we'll go on and talk about the next topic. So you've got them in front of you as well, haven't you, Krishma?
I do.
Let's have a look at them. Do you want to read out
so
the questions?
I've got a question here.
We dealt with the first one.
We dealt with the first.
So we're going for the second one.
We're going for the second. And the question is this a test regarding whether Anna can comply with the order? Is the test regarding whether Anna can comply with the order a practical one? I.e., can the flat physically be cleared, or is it whether she can decide to comply or not?
I think that the reason I said let's answer these questions, because I think that's a great question. I think we should deal with it. It is not about whether the flat can be cleared or can't be cleared. I'm not talking about now about solutions to the problem. We haven't quite got to that bit yet, actually, in this webinar. We're now talking about whether Anna has capacity, which is a legal question. And the answer to it, remembering the functional test and the diagnostic test that you've talked about, does she, Anna, have the ability to make a decision to clear her flat? Or to even make a decision about whether she wants to clear her flat or not? That's all. Now, once you've got an answer to that question, and probably she doesn't have the ability to make that decision, because if she did, in the cases that we see, things have got so bad that almost by definition, as we said before, if the person had capacity, they would have started to deal with the problem. So the fact she's not dealing with it almost certainly means she lacks the ability to make a decision to deal with it. So in answer to that great question, it is not a test of whether the property can, practically speaking, be cleared. It is a test of whether Anna is capable of making that decision. That's the answer to that one. Got lots of questions. Let's try and go through them, and then we move on to the next
Okay, so next question here. Who should make the assessment as to capacity?
There is no statutory rule about that. Sometimes it's really obvious, and the solicitor acting on behalf of Anna might be able to assist with that, or a housing officer might be able to assist with it. If there's any uncertainty about it at all, and sometimes it isn't obvious, sometimes from what the tenant says, it seems like they do understand, but just don't want to do the clearing. If there's any uncertainty, then you're going to need a psychiatrist or similar mental health professional to make that assessment. And to be fair, because the Act has been in place for almost 20 years now, medical professionals are very used to making capacity assessments. It's really easy to get that assessment organised. Okay, next one.
We've got another one. Are you saying that antisocial behaviour injunctions may be necessary? Are you saying that, and the question is, are you saying that for ASB injunctions it may be necessary to obtain a medical report to identify issue-specific capacity before contacting Board of Protection?
No, it's not as if there's a sort of evidential rule that says that without medical evidence you can't do X, Y, or Z. It's simply that the jurisdiction of the Court of Protection is not engaged unless the person lacks capacity. So the first thing the Court of Protection will want to see is evidence that the individual lacks capacity before they will accept jurisdiction. Equally, no rule of evidence or law that says that a court can't hear an application, county court can't hear an application for an antisocial behaviour injunction without evidence of capacity. Indeed, I suppose in a sense the opposite, the county court will assume there is capacity because that's the requirement of Section 1 of the Mental Capacity Act. It's just that if, as you go through the process of applying for an injunction, it becomes pretty obvious pretty quickly that the person is incapable of complying with an injunction because they can't control their decision making sufficiently to actually take steps to begin to declutter, then a judge simply isn't going to make that order. So why, and this is what you said before about waste of time and money, why start the process of seeking an injunction with the cost and resource that entails, and probably also the bad feeling that Anna will have from being subject to that process, if in the end a judge is never going to make that order. So in answer again to that excellent question, there aren't procedural requirements there relating to assessment for capacity. It is that you need, in practical terms, to know whether Anna does or doesn't have capacity so you can decide what to do.
That was really helpful, Iris. And there is a question here about something that looks like it's quite specific.
It's quite a common type of term in a tenancy. But should we read it out?
So the question is, our tenancy terms and conditions allow us to force entry into our properties if urgent health and safety risks arise. For example, a leak if it's a danger to a person or a building. I wonder if you know if the law allows us not to force entry. Not only to force entry, but also to remove any hazards, to stop any leaks, etc. If the property is so dangerous, as in there's a risk of fire and there's lots of rubbish, for example, that's flammable, and the tenant is using dangerous equipment, can we do a change of the locks and put them into an emergency accommodation, or would you advise that we should get an injunction and or a possession order to force them out?
I think that's a very good question, very complex. The answer to that I am going to park, because really the answer to that question is what happened in the case of Anna. And I think we're going to cover that as we go through this webinar. So what to do about something as serious as that is a very important question, and we will get to that. Okay, couple more. Oh my goodness, we might have to stop in a minute and carry on with our agenda. Otherwise, we'll never get to the end of the webinar.
Okay, just another quick one on capacity. What can you do if the tenant refuses to agree to a capacity assessment, and or neither the landlord or social services are willing to assist with carrying out a capacity assessment?
Well, I suppose it depends whether it's pretty obvious that the person lacks capacity or it's not obvious. Let's start with the first one. If it is pretty obvious the person lacks capacity and you would like to have an assessment, but you can't get agreement, engagement from Anna or from social services to have that assessment, you could proceed on the basis that you believe she does not have capacity, and then decide what to do about that. And if you decided, for example, to apply to the Court of Protection for an order because you considered that she did not have capacity, the Court of Protection may choose to make an order requiring the local authority to assess her for capacity. So you could choose to take steps on that basis. You could issue a claim in the county court pleading that you consider she lacks capacity. If it's not obvious whether or not she lacks capacity and she is refusing to engage, you can work on the basis of the statutory presumption, which is that she doesn't have capacity. And then you can seek an injunction. And then at some point she will take advice, and then she will plead that she doesn't have capacity because it will assist her in avoiding an injunction. And then at least you've got an assessment that will have to be conducted at that stage to deal with that issue. I think perhaps we'll stop there and we'll come back to the questions at the end. Because they're going to keep coming, I think, otherwise. So let's park the rest of your questions. Apologies if you've got questions that we haven't answered yet. We will come back to them all at the end. But let's talk about what happens after capacity is considered by the landlord. So let's say, Krishma, we have identified capacity is an issue. We have arranged either to get medical evidence about it, or there's been a failure of engagement and we've taken a view one way or the other about capacity. Is that it? Tell me, is that the only question the landlord needs to ask before ploughing on with the next practical steps?
I don't think so.
No, right, correct. The answer, apart from no, is we need to think about disability.
Yeah.
The possibility that the tenant is a disabled person. Now, that is a completely different thing from capacity, and that is a very important point to make. So for the people who watch this not live, you'll suddenly find us looking slightly different because we've switched to the laptop, which is totally fine.
Yeah.
And this is why whenever IT can be avoided, it should be. Absolutely. Okay, I'm going to just rewind a tiny bit. Capacity is about a person making decisions for themselves and whether or not they can do it. Disability is about whether the person has extra protections under the Equality Act, meaning that the landlord will have potential claims of disability discrimination against it if it isn't very, very careful about how it deals with the issue. Yeah. Okay.
A question for you, Morris.
Yes.
Is it possible to have capacity but be disabled, or to not be disabled but lack capacity?
Oh, absolutely. Yes, absolutely. The definitions are completely different. You can be able to make decisions but be disabled, or you can be unable to make decisions but not be disabled. So, definition of disability, Section 6 of the Equality Act, a mental or physical impairment. And remember, your definition of capacity was about mental impairment. So a mental or physical impairment which has a long-term substantial adverse effect on the person's ability to carry out normal day-to-day activities. And long-term means 12 months or more, or likely to last for 12 months or more. So just to illustrate this, let's try an easy question. Can you think of an impairment that would be a disability, but that does not affect capacity at all?
Okay. What about somebody that's suffering from diabetes?
Yeah.
Or someone that uses a wheelchair? So these people would be disabled, but their disability would have no effect on their capacity.
Right, absolutely, agreed. Now, what about a more difficult one? Can you think of a situation where someone might not have capacity to make decisions, but not be disabled?
What if someone was in a car accident?
Yeah.
Was unconscious in a coma as a result of their injuries,
Yeah.
and therefore unable to communicate for a period of 3 months.
Right.
But then they make a complete recovery after 3 months. That would mean that that person would lack capacity whilst they were in a coma, but it wouldn't be long term, and so it wouldn't be a disability.
That's exactly right. Exactly right. So they are really two very distinctly different things, and it is perfectly possible to have one and not the other. Although often in hoarding cases, the person will both lack capacity to make the decision about decluttering and also be disabled. But in principle, you have to start with those two questions in every hoarding case. Is this tenant likely to be disabled? Does the tenant seem to lack capacity to make decisions about their hoarding behaviour?
So that's very clear so far.
Yeah.
But what happens next? So what sort of practical steps take place after this? Okay,
well, your landlord is going to be thinking, if they have the ability to apply for an injunction, if they are a local authority or a social housing provider, would an antisocial behaviour injunction work? So that's a question. Are they a local authority? Can they apply for a notice, or can they, serve a notice under Section 287 of the Public Health Act? That's the notice that forces the person to be removed, to remove clutter from the property. Could a court of protection application work? Could sectioning work? If none of those is an option, the option remaining, and perhaps as we said earlier, in a private landlord case, maybe the only option is eviction, in other words, obtaining a possession order. So those are the things that the landlord, having considered whether the tenant is disabled, having considered whether the tenant lacks capacity, they're going to be thinking about which of those steps they might be able to take.
So all of the steps that you've mentioned are sort of legal decisions or legal steps.
Agreed.
But is there anything that a landlord could do in advance of taking those steps?
Oh, yes, absolutely. Don't get me wrong. Those are final steps.
Yeah.
Before you get to any of that, it's extremely important that you have to start by considering really every other possible solution. And I say considering, I don't mean you have to do things that are impossible to do, but you have to consider as a landlord every other possible non-legal step and solution. For two reasons, I would say. Number one, because it is actually much more likely to be successful in resolving a problem if the tenant is engaged and willing to take the steps that are needed in order to solve the hoarding problem. So finding a solution that doesn't force them to do something is always the best option if it is possible. I realise it's often not possible, but if it is possible. And second, so first, it's a good thing to do. If it works, it's the best way of doing it. But second, this person, whoever they are, who is hoarding, is very, very likely to be disabled, right? And because of the way that the Equality Act operates in relation to disability and the particular types of claim that arise when a tenant is disabled, the reality of the situation is that any legal step is only going to be lawful if it is proportionate. And it is only going to be proportionate if everything else bar that step that is less draconian than that step has been considered and either tried or can't be done before getting to that step. That's really what proportionality is all about.
And so in terms of these less draconian steps, before we get to sort of the legal steps, what do you mean by that? Shall we recap?
Yes, now we started with a bit of a chat about those practical things. Let's go through that in a bit more detail now, shall we? So definitely the landlord needs to engage with the tenant, talk to them face to face, or try to. And that involves asking the tenant. So let's continue to talk about Anna. Asking Anna what she wants to happen, what she thinks she can achieve, bit by bit. Try to make what we often call a clearance plan with Anna. Now, there are two flavours really of clearance plan. There is a clearance plan that a landlord might contemplate where the situation is urgent. And there are two main, well, maybe three actually, three main types of urgency with hoarding. The first one most commonly is fire risk. You not only just the sheer amount of paper in the property, but quite often, unfortunately, the tenant will be cooking on an open gas fire with paper everywhere. So it really, and they're in a block of flats where there are other people living that are in danger. So fire risk is a very urgent, very common problem with severe hoarding. Second is vermin risk. With lots and lots of piles of paper, you get rats and mice and other pests. And that's obviously a risk to health to both the tenant and to other neighbours around them. And thirdly, you do sometimes get literally cases where the ceiling is in imminent risk of collapse because of the weight of paper. Usually it's paper in the flat, which is above ground, in a flat which is above ground level. So those sorts of urgent types of situations, you might have a clearing plan which you try to agree with a tenant, which is quite drastic and requires clearing quite quickly, but trying to plan it and agree it with the tenant. If there isn't that urgency, yes, it's in the long term, it has to be sorted out, but there's no immediate fire risk, no immediate vermin risk, and no immediate imminent building collapse risk, then you've got the other type of clearance plan, which is a very slow, very deliberate, very clearly defined set of steps, which may literally start with an agreement to deal with one particular pile of paper in the bathroom, on the bathroom cabinet, because that tenant feels able to do that, and that might need a month or 2 months with the help of person X, Y, and Z, and then you build into that clearance plan little steps to start to move things away from where they are currently being stacked and into a different part of the flat to start to go through them. So it's really that sort of plan that you're considering unless you've got a very urgent situation. So talk to the person, find out what they want, try and agree a clearance plan with them. Is Anna herself, is the tenant herself asking for some particular step to be taken? Is that does that seem silly to
Mm.
you? Is it something trivial, something useless, something annoying, something that seems irrelevant to the issue? But Anna is adamant that she really needs that doing, whatever step it might be. Well, do it. Do it. If it's something that will mentally unblock for Anna the problems of beginning to declutter, you're going to be criticised by a judge if you don't do it.
Okay.
So if there's something that Anna is asking for, even if you think it's silly and it's not needed, do it anyway. So ask her what she wants, and if possible, do it. Find out if there is anybody, we talked about this before, that Anna knows. This is often really helpful. A member of her family, a friend, a neighbour that she trusts, that with the help of that person, she would be willing to start to do the clearing. Find out if there is any such person and get them involved if you can. Private landlords, this is less likely to apply to, but a large landlord or a social landlord is very likely to have a hoarding policy. Precisely because tenants with hoarding problems are so difficult to deal with that actually a policy is, if you've got any size of organisation, a policy is really necessary. So many large landlords do have hoarding policies. And you won't be surprised, Krishma, to know that if you've got a policy, you've got to follow it. So you definitely will be criticised by a judge if your policy says you're going to do X, Y, and Z, and then you don't do it. So follow the policy, but equally be prepared to go beyond the policy as well. So don't be limited by what's in the policy. Do everything the policy requires you to do, but also think creatively outside the policy as well. We've talked about the officer making their own assessment of hoarding levels using the clutter image rating system. That definitely needs to be done so that the landlord can assess how bad the situation is and how much there is to do. If the landlord is a local authority or a large social provider with good links to the local authority, it's very commonly helpful to hold multi-agency meetings. So that's meetings with adult social care, meetings with mental health professionals, with social workers who've been involved with Anna, people within the local authority under the various departments of the local authority who have knowledge of Anna's circumstances. Again, as we keep saying, hoarders often are people with very long-term, intractable, difficult mental health problems that are known to social services. So the likelihood is the local authority can pull together a number of people from different departments who know the circumstances of the individual. And if you are the landlord and you're not the local authority, get yourself involved in that multi-agency process so that you can input into it. What are the practical steps? Try to persuade Anna to engage with tenancy support if she isn't already. Try to persuade Anna to engage with medical services. Long term, try to persuade Anna to engage with counselling services and psychotherapy services, because almost always, perhaps even always actually, the cause of cluttering is trauma, is a past trauma, and that person, the symptoms that person exhibits from post-traumatic stress disorder of some kind following on from that trauma is the cluttering behaviour, the inability to let go of things. So the counselling or psychotherapy is actually the real solution, long-term solution to the problem. Try and help that person, if possible, to get to the point where they're willing to accept some counselling. And I think perhaps we've covered this, but sometimes a tenant, very rarely I suppose, has not yet been referred to adult social care. So make that referral if you can, if that hasn't happened yet. So all sorts of things to think about, very practical.
Lots of practical steps there, but what if particular steps have already been tried? So to give an example of a difficult situation, what if it's dangerous to attempt those steps again? Like in our example, if Anna is violent towards housing officers could attempt to visit, or what if it's really urgent, such as there being a really imminent risk of fire, for example.
Okay, like we talked about
open flame, surrounded by papers, block of flats.
Okay, so if you've got things that you could do, but you feel you can't do them, either because there isn't time or because it's dangerous, then I would say this, and I always say this, so the people who are watching this webinar who know me know that this is one of the things I always say, which is a good paper trail makes a difficult case easy, and a poor paper trail makes an easy case much more difficult. It is not to minimize the practical steps, but in terms of litigation, the paper trail makes all the difference. So it is no good, for the purposes of going to court later, it is no good doing something if you haven't recorded it. You have to be able to prove to a judge that you've tried doing a particular thing, because Anna could turn around and say, no, he never turned up, he never said that to me, never offered me a temporary decant and to help me with the clearing. That never happened. Well, if you haven't made file notes about that meeting where you've set out, well, we had the meeting with Anna and we offered her this and she said no, how are you going to be able to prove that that even happened? So a paper trail. But also, let's reverse that. Often it is possible to justify not doing something that seems really obvious to a judge needs to be done. It's sometimes really obvious to justify why you haven't done that if you do have a good paper trail.
And do you have an example of that? For example,
Yeah.
practice or
I do actually. I think the best illustration of that sort of situation where you've got a really extreme situation, but actually the paper trail is really good, and you've explained it all, is the case of Anna itself. That case report, a local authority versus X, August 2023. It's a reported case, you can look at it. And that's a case, and this is not a webinar about the Court of Protection and the way the Court of Protection operates, but essentially what Court of Protection judges do is they make decisions about what is in the best interests of the person who lacks capacity. And the judge in this case was being asked to decide what was in the best interests of Anna. I'm going to continue to call her Anna, she's X in the case. And in the case of Anna, the judge decided to remove Anna forcibly from the flat against her will, with the inevitability of very, very serious distress to her, so that it could be cleared, so the flat could be cleared against her will before she was then moved back into the flat. And I'm just going to read to you a couple of the paragraphs, beginning, for those of you who are keen, you can look at paragraph 104 onwards of this case report after you've watched this webinar. And I'm just going to read it to you because it is just so striking how important the evidence trail was in this case. And this is what the judge said. Having stood back and looked at the wide canvas of evidence, the court is really faced with a binary best interest choice. Either Anna remains in the property with no prospect of any change, which is very likely to get worse, in a situation that is described as being a significant fire risk to her, along with the many other risks outlined above, or steps are taken to seek to bring about change. However, this latter course is not without its own risks, bearing in mind Anna's very strongly held wishes, the very high level of distress she is likely to experience, her threats of suicide, which need to be taken seriously, and the significant interference in her Article 8 rights that such a move entails. There is no middle ground that has any credible evidence to support it. Based on past experience, any further attempt to support Anna to bring about change is certain to fail. I've reached the conclusion that Anna's best interests are served by the local authority application being granted. In doing so, I readily accept the considerable risks that are being taken in overriding Anna's expressed wishes and the consequences for her of such a step being taken, bearing in mind her mental disorder and the threats of suicide that she has made. Those matters weigh heavily in the balance. Having said that, I consider the balance is tipped the other way by what I regard as the substantial and increasing risks Anna would be left exposed to if this order wasn't granted. They are serious risks that would have a direct impact on Anna's health and safety. There is no prospect of any other step being taken that would bring about any meaningful change. The evidence set out in the detailed contingency plan, so that's a plan made by the local authority in this case, includes provision that would seek to mitigate the impact on Anna of what is proposed by the by the multidisciplinary approach, where Anna would have the continuing involvement and support of the official solicitor and a hearing to review the next steps by the court. In approving the steps outlined in the contingency plan, it will also mean that Anna's best interests will be served by an order that deprives Anna of her liberty in the temporary supported accommodation she will move to. That order will ensure the main purpose of the order to clear Anna's flat takes place with the aim of enabling Anna to return to the property. So I've got quite a long citation, but it's important, I think, to show you just how severe an effect can be on a tenant, and the court might still make that order. And coming back to that initial question about private landlords versus social landlords, capacity has nothing to do with public bodies. Capacity is a matter that any party is able to deal with. And we, in fact, quite often the Court of Protection deals with claims relating to individuals, not relating to local authorities. So a private landlord can engage with those matters if it needs to as well. So just to summarise, I suppose, what the judge says in the case of Anna, when everything else has been tried, when everything else has already failed, when the risks are very serious, it is even possible to get an order from the Court of Protection, if there is a lack of capacity, to remove the tenant forcibly from the flat, detain her and forcibly clear the flat against her will. Now, that's a lack of capacity case. The county courts do not have those sorts of powers. Okay, in a case where a tenant does have capacity to clear the clutter and doesn't do it, so in that case, Court of Protection is not an option. In that case, the equivalent effectively in the county court is for the landlord to go for an order for possession, despite disability, because most likely the tenant's going to be disabled. And despite the, inevitably very serious effects on a severely disabled, mentally disabled individual of being evicted from their home, you can get that order as a landlord if you have laid out for the judge everything that has already been tried and why it hasn't succeeded and why the risks to the person and to others around them are so very serious.
And really, really useful authority actually, and quite helpful for you to read out the judgment that actually sets everything out quite clearly. Shall we summarise everything now that we have talked about during this talk? So,
yes, please.
To start with, most important thing is to assess capacity.
Yes.
To assess the likelihood also of the tenant being disabled. And with hoarding, we've talked about how they will almost always will be. Yeah. If the tenant lacks capacity, then the Court of Protection may be the only formal route, other than seeking possession, for example, which we just touched upon.
Yeah.
If the tenant doesn't lack capacity, but is likely to be disabled,
which is probably the situation quite often,
then the landlord must do everything possible to resolve the hoarding problem. So that could mean following all internal relevant policies, and also be willing to try things that go over and above the policies.
Yes.
But what's really important in terms of any actions that are taken is to ensure that there is a proper paper trail. All of the steps must be documented, and that's very important because it's only in that situation where, for example, if you're seeking an injunction, the court may grant an injunction in considering that actually all of these steps have already been taken and nothing has worked thus far.
Right.
And if all of that doesn't work,
or if you're a private landlord, you don't have the option of going for an injunction,
then a possession order is something that you can think about. Okay, so that
questions. Let's go back to those questions then. So I think that's a pretty good summary of what we've been chatting about. So let's have a look. We've got loads, loads and loads of questions. Let's pick through them and just see. Looking at the time, it's just after 6. Let's take sort of 10 minutes of questions.
Sure.
And pick the ones that have the most general application. I think we've talked about not getting permission for medical reports already. Something about costs. Should we deal with that? Do you want to ask me the question about costs if you can find it? It's the one that was sent at 5:24.
5:24, here we are. Okay. So the question is, will costs of preliminary proceedings always be payable by the landlord if it's the only way to confirm capacity?
I suppose the practical answer to that is we all, I think, know from our practice in housing law that it's almost always very difficult to obtain an order, an enforceable order for costs against a tenant. That's more possible where you've got a private rented property and the individual has an income or has assets. Most of the time, particularly when you've got people in social housing, you may get a costs order, but you may not be able to enforce it. And in practical terms, the answer to that question is the reality is the landlord is going to be soaking up those costs. And there isn't really an alternative to that because you have to establish whether or not the person has capacity. Very occasionally, the court is willing to pay the cost of assessing capacity itself. But I'm afraid the reality is if you're a landlord seeking an order from the court and there's a question of capacity, the court is almost certain to order the landlord at its cost to assess capacity. So not really the answer I suspect that the person asking the question wanted, but that's the reality.
Yeah, absolutely. Another question for you, Iris. Sorry, I'm just going through the questions.
Well, there's a nice one about injunctions, which I've got here at 538.
Yeah.
If a person lacks capacity, is the injunction application court of protection, or should it start in the county court? I think that's an important point. So there's a suggestion here of sort of moving from between the county court and the court of protection. Let's make it very clear they are two completely separate jurisdictions. There is no procedure for moving between the two at all. Let's break this down. If you consider a person lacks capacity, then the reality is you won't get an injunction at all, so you shouldn't even start that process because they will not have capacity to understand what the order means. I'll talk about the court of protection again in a moment, but bear in mind that in generally speaking, in litigation of any kind, it isn't a bar on litigation for a party to lack capacity. And we know that because there is the process called appointing a litigation friend. Right? Litigation friend gets appointed for a person who lacks capacity to litigate. So it's perfectly possible to have a claim for possession against a tenant who lacks capacity. And that happens relatively frequently. That person has to have a litigation friend appointed before the case can proceed. But it is not uncommon to go straight to possession without seeking an injunction in a case of antisocial behaviour if the person lacks capacity to have an injunction made against them, because effectively you don't have any other steps that you can take if you're a social landlord and the tenant lacks capacity other than resolving outside of court proceedings or taking possession. So the answer to the question about capacity with injunctions is assess it before you even start. Now, if you are pretty confident that the person does lack capacity and you're not going to get an injunction on that basis, then forget the county court, go to the court of protection to seek the sort of order that we have in Anna's case. But let me also just highlight that those sorts of orders, like the one that was made in Anna's case, are very, very, very rare. It's much more common to say, there is a problem. The person lacks capacity, therefore we can't get an injunction, so we'll go for possession. That's what tends to happen. That is what in reality. Perhaps it should be more common to go to the court of protection. The reality is this was a local authority and it had the facilities, the resources perhaps. We don't know which local authority it was, but it's a very resource heavy and cost heavy process to take a case like that through the court of protection.
It is.
I would have thought the private landlord will not be criticised for just going straight for possession if there is a problem of this kind without going to the court of protection at all. Let's see. What about an elderly person? We've got a question from 541. Do you want to have a go at that, Krishma? What's the answer? I mean, what are the questions to be asked, do you think, if the person is elderly? Do you think there's any difference in terms of what we've talked about?
I don't. I think the issues are all the same in terms of capacity, in terms of the disability.
There might be more medical information.
Exactly.
Because an elderly person is more likely to have spent time
longer. Exactly. So there might be, by way of medical evidence or information, you can glean a bit more from.
And you might be able to get a good assessment of capacity without needing extra assessments potentially.
But really, I think the central questions that you covered during the talk still stand even in that situation. There just might be more medical evidence available.
And you know, Anna's case, we don't think Anna was an elderly person. There's no suggestion in the fact that she was, but she had all sorts of vulnerabilities that made it very difficult for the court to decide what to do. in just the same way, if the hoarder is an elderly person, and quite often the hoarders are elderly, that does happen quite often. That's going to be one of the factual points that a judge will have to take into account, that being evicted or being forcibly removed from a home where they perhaps have lived for decades is going to be even more traumatic for them than it would be for a younger tenant who hasn't lived there for very long. Let's see. Okay, there is a very interesting question, which I honestly don't think we have time to really do justice to, which is a question, Krishma, from 553. If a tenant asks for reasonable adjustments, namely for landlord to pay to clear the property on a regular basis, but the landlord is unwilling to meet the cost, to what extent is that a lawful or legitimate reason to refuse the request? Similarly, is it lawful or legitimate to limit the willingness to pay for regular house clearing? That's a great question.
That's a very interesting question.
I mean, ultimately, let me say in practical terms, genuinely, if the tenant is willing to have the property cleared and it's a relatively trivial cost, that is so much easier than all the other steps we've been talking about. It's probably cheaper, easier, simpler and better to do it. Forget for a moment the legal answer to that question than not to, particularly if you're a social landlord or a local authority. Private landlord, I appreciate, will have completely different issues, and private landlord could literally be a person who just owns one property where they just don't have the resources to do that. So that is a reasonable adjustments question. Reasonable adjustments are a technical area under the Equality Act. The obligation on a landlord, and it is not just social landlords, it's any landlord, private or social, is to consider whether there is a policy, a way of doing things by them, what we'll call the PCP, the provision, criterion or practice, a way of doing things that they have that substantially disadvantages Anna because of her disability. And if there is some way, some policy or some way of doing things that does substantially disadvantage Anna because of her disability, then the landlord has a duty to take reasonable steps to alleviate that disadvantage. Now, let's fit that into what we're talking about in this excellent question. The disadvantage of, first of all, the policy obviously is we don't do house clearing for our tenants and we don't pay for it. That's obviously sensible and the normal way of things. Now, with reasonable adjustments, you don't look at the normal way of doing things, you look at making adjustments to the normal way of doing things. So Anna is saying in that situation, well, okay, I know usually you don't pay for clearing, but I'm asking you to because I need it for my particular disability. Because if you don't help me to clear, the fire risk is going to increase, the vermin risk is going to increase, I'm unhappy, you know, it's bad for everybody, and you're going to try to evict me for breaching the terms of my tenancy because I'm not able to do it myself. So would you please, as a reasonable adjustment to your normal policy of not doing those things, please do it. And then there is a very difficult to predict balancing exercise of what is reasonable. And unfortunately, with reasonable adjustments, it's impossible to absolutely predict what's reasonable and what isn't, because it is one of those things that a judge decides at some point in future when you litigate the situation and the tenant defends it by saying you failed to make a reasonable adjustment. Then a judge decides whether or not it was reasonable for you, this particular landlord, to regularly pay for decluttering. And you have to bring forward evidence to show why, not just that you're not willing to do it, but why. What's the cost? What's the burden on you? Can you afford to do it? What's the equivalent cost to you of not doing it? Does not doing it generate other costs so that ultimately it actually makes a lot of sense to just pay for the decluttering? All of those things, very good issues to think about, very important issues to think about. I think, by the way, in reality, 99% of the time, the tenant isn't willing to let the landlord do the decluttering. They're not willing to engage at all, one way or another. And in a strange sort of way, that's easier. With a tenant who is willing to engage and wants certain things done that will cost the landlord something, then you are into the realm of reasonable adjustments if that tenant is disabled, which, as we said before, they almost certainly are. Let's see. Realistic timescales for engaging the Court of Protection for an order in respect of hoarding. Very, very, very slow.
it takes, not only are they overworked and it takes a long time to get a hearing, unless it's absolutely urgent, but the Court of Protection judges will want to explore all of the evidence and all of the other things that could be done before they're willing to make the sort of order that happened in X's case, in Anna's case. So it is not a quick solution.
It's very draconian, isn't it?
It's very draconian. That's right. The case reference for local authority and X, I don't think there is one. Have you got the case? Yeah, just go to the top of it and see. I think we might have it for you. Just a moment. Oh, there it is. Yes. So it's 2023 in square brackets, EWCOP 64. 2023 EWCOP 64, and the date of the judgment is 16th of August 2023. Couple more questions and then we're done. As a social landlord, where a tenant lacks capacity, you have the option of seeking an order via the Court of Protection or going to the County Court for possession. Is there any restriction on taking either course of action, or must one be taken first? Or can the landlord decide on the appropriate option from these two in the circumstances? First thing to say, certainly the Court of Protection will not expect you to have sought a possession order before you go to the Court of Protection.
Yeah.
So logically, you can certainly choose to go to the Court of Protection first. The real question here in practical terms is, will the county court criticise you for not having first tried going to the Court of Protection to resolve the issue? In my experience, I've never even seen that argued by a tenant as a basis for avoiding possession, but it could be argued. It's not a restriction as such, it's more a question of a defence under the Equality Act by a tenant saying there are other things you could have done that would have been more proportionate than this before coming to the court seeking to evict me. And one of those things was trying to engage the Court of Protection. This kind of links into the previous question, because the cost and timescales are so huge in the Court of Protection. I don't know, what do you think, Krishma? I don't think County Court judge would necessarily think that it was proportionate to have to go to the Court of Protection before seeking possession.
I mean, I agree, especially if you're a private landlord, for example, and you don't have the resources. You can see in that situation how
a judge might be.
Exactly.
I think it's so resource heavy. I think that's right. I think the bigger you are as a landlord, particularly if you're a local authority, there could be an argument of that kind. But I must say, I've never seen it argued. Maybe, you know, those of you who are tenant solicitors who are watching this might think about this as a possible argument in a possession claim relating to hoarding on the sort of rebuttal to the proportionality issue, to say, well, this isn't the right step to take because the Court of Protection hasn't yet been engaged to try and resolve this in a different way. And then finally, I think we have sort of covered this. Let's just make sure we got it really clear. Would a non-local authority landlord have standing to bring proceedings in the Court of Protection? Yep. Anybody can. I say anybody can. There are certain requirements in the Court of Protection because, of course, Anna herself lacks capacity. So she isn't a person who can bring the proceedings. But if you have standing, if you have an interest in the decision that Anna is unable to make as a landlord, then you can make an application in the Court of Protection. Bear in mind, I mean, going back to the time limits, the time point, and the fact that these things take a long time, it may be that once you go to the Court of Protection, the official solicitor needs to become involved. In Anna's case, in the case of X, there wasn't somebody willing to act as her deputy and to assist her or anything like that, and therefore the official solicitor had to become involved, and that takes time because the official solicitor is busy and they've got lots of litigation that they are dealing with, and you have to just wait until the official solicitor is ready and engaged and dealing with the case. So it is by no means an easy solution, and that's why the reported case of local authority and X is so unusual and worth reading. Most of the time you will find that these cases go to an injunction if possible, and if not, to possession.
But I definitely echo that. Reading the judgment, really, really interesting and really quite useful actually in terms of thinking about practical things that can be done before you reach the legal process.
Yeah, and also a sort of salutary lesson in how very complex
Yeah,
and
yeah.
slow
Yeah.
that process might be.
Yeah, absolutely.
So thank you for watching this webinar presented by us, Iris and Krishma, at 42BR Barristers. This has been a webinar about hoarding litigation, what to do and what not to do. You are going to receive a feedback form and a recording that will be sent to you in the next few days. So keep a lookout for that. And please do also keep an eye out on our website, 42br.com, and on our social media for our next housing webinar.
Yeah, thank you very, very much for joining us this evening.
Bye-bye.
Bye-bye.